You're sitting in the back of a police car, red and blue lights flashing in the rearview mirror. An officer leans in and you have the right to remain silent. You've heard those words in every cop show, every crime drama, every courtroom thriller, but do you actually know what they mean or why they matter? Welcome back to Due Process Daily, where we turn headlines into hard law and make sure you know your rights before you need them. Today, we're diving into one of the most iconic legal protections in American history, your Miranda rights. You've probably heard the phrase 100 times, but the truth is, most people don't really understand how it works, when it applies, and most importantly, when it doesn't. Let's clear that up. First things first, what are your Miranda rights? The phrase Miranda rights comes from the landmark 1966 U.S. Supreme Court case, Miranda versus Arizona. In that case, the court ruled that before police can interrogate someone in custody, they must inform the person of certain constitutional rights, specifically the right to remain silent and the right to an attorney. So, why is this such a big deal? Well, think about it. Police interrogations are high-stakes, high-pressure environments. People get scared, confused. They say things they don't mean or don't understand. And before Miranda, there was no clear legal requirement to warn suspects that they didn't have to talk or that they could get legal help. So now when you hear, you have the right to remain silent, that's not just a dramatic line. It's a constitutional safeguard. It's there to protect you from saying something that could be used against you without fully understanding the consequences. Here's what a standard Miranda warning includes. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed to you. That's the basic script. But here's where things get tricky. Miranda rights only apply under two conditions: custody and interrogation. Let's break that down. Custody means you're not free to leave. If a reasonable person in your position would believe they're being detained or arrested, that counts as being in custody. You don't have to be in handcuffs. You don't have to be in a jail cell. You just have to be in a situation where you can't walk away freely. The second condition is interrogation. That means the police are asking you questions that are likely to elicit an incriminating response. Casual conversation, not necessarily interrogation, asking for your name and address, also not interrogation. But the second they start asking about where you were, what you were doing, who you were with, that's likely interrogation. If both conditions are met, police are required to read you your Miranda rights. If they don't, and you say something incriminating, that statement might be ruled inadmissible in court. Notice the word might, because there are exceptions. Here's where things get even more complex. Let's say you're in custody and the police start questioning you without reading you your rights. You confess. If your case never goes to trial, or if the confession leads to evidence that's found independently, it could still be used. Also, if you blurt something out before the police even start questioning you, like an unprompted confession, that might still be admissible. That's called a spontaneous utterance. There's also something called the public safety exception. If the police think there's an immediate threat to public safety, like a hidden weapon or an ongoing danger, they can ask questions before reading you your rights. That evidence might still be allowed in court. So no, Miranda is not a get-out-of-jail-free card. It's a protection, not a loophole. Another common misconception: if the cops don't read you your rights when they arrest you, your case automatically gets thrown out. Not true. Miranda rights only matter when it comes to using your statements in court. The arrest itself could still be valid. The evidence they gather might still be admissible. It depends on how and when the statements were made. Now let's talk about what you should do. If you ever find yourself in that situation, let's say you've been taken into custody and the officer starts reading you your rights. First, listen carefully. Second, take those rights seriously. When they say you have the right to remain silent, they mean it. You don't have to explain yourself. You don't have to answer questions. You don't have to clarify anything, and you probably shouldn't, at least not without an attorney present. Here's a key detail most people miss. You have to clearly invoke your right to remain silent. Just staying quiet isn't always enough. Courts have ruled that unless you explicitly say something like, "I'm invoking my right to remain silent," the police may continue questioning you. Same goes for your right to an attorney. You have to say it clearly. I want a lawyer. Once you say that, the police are supposed to stop the interrogation. until your lawyer is present. If they keep asking questions and you respond, those answers might not be admissible in court. But again, it depends on how it all unfolds. There have been a lot of major cases that shaped Miranda rights over the years. In Berghuis versus Tompkins, 2010, the Supreme Court ruled that remaining silent isn't the same as invoking your right to remain silent. That decision shifted the burden to the suspect. If you want your rights to apply, you have to assert them clearly. In Missouri versus Seibert, 2004, the court dealt with a police tactic where officers would intentionally delay giving Miranda warnings until after the suspect had already confessed. Then they'd Mirandize the suspect and have them repeat the confession. The court ruled that tactic unconstitutional, saying it undermined the whole purpose of Miranda. The bottom line is this: Miranda rights are powerful, but they're not automatic. You have to understand them. You have to use them, and you have to say the right words at the right time. Now, here's something else that's important to understand, especially in the age of viral videos and high-profile arrests. Miranda rights are only about what happens during custodial interrogation. They have nothing to do with your rights during a stop and frisk, a traffic stop, or when you're just filming the police on your phone. Those are separate issues, important, but not Miranda-related. So, if you're stopped on the street and questioned without being detained, the police don't have to read you your rights. That doesn't mean you don't have rights. It just means the Miranda warning isn't required. So let's recap the key takeaways. Miranda rights protect your Fifth Amendment right against self-incrimination and your Sixth Amendment right to legal counsel. They only apply when you are in custody being interrogated. To use them, you must clearly say, "I am invoking my right to remain silent. I want an attorney." If you don't say that clearly, you could accidentally waive those rights, and the police can keep questioning you. That's why understanding your rights before you need them is essential, because here's the truth: nobody expects to get arrested. But if it happens, the last thing you want is to be making legal decisions without knowing the rules of the game. And now you do. Thanks for tuning in to Due Process Daily. If you found this video helpful, informative, or eye-opening, help us keep the channel growing by liking the video and subscribing to the channel. The information contained in this video is for informational purposes only and does not constitute legal advice.